Hello, everybody, and welcome back. I still have decided not to go on camera because I currently still look like death warmed up. I am almost out of the woods in being sick, but still not feeling 100% and not looking my usual best. So yeah, here's an image on the screen of me looking real pretty a couple of days ago. But anyway, lads and lassies, I've got a very interesting one for you here today. This lady's in court now. She doesn't appear on camera, but she is in the background talking now. I'm just going to give you a heads up. There's a lot of background noise from her and kids screaming and stuff like that, and the judge has some stuff to say. Basically, this woman, to narrow it down to a very fine point, thinks that she shouldn't have to pay rent because she's got a leaky faucet. That's a tap for us here on this side of the planet, a tap. Anyway, so because of this leaky tap faucet, she thinks that she basically can squat there forever. She argues with the judge, and the judge is basically like, that's not the law. And she's like, Your Honor, as I'm sure you're aware. And the judge is like, no, I'm not, because that is not the law. But anyway, lads and lassies, I hope you enjoyed this video. If you do, make sure and give it a thumbs up, and we'll catch you in the next one.
Good afternoon. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. The court will call the matter of the Ranches of Rosebrook versus Anise Battle, case number 25C-1245.
Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Ms. Battle, could you please state your name?
Battle.
I'm sorry, could you repeat that?
My name is Denise Battle.
Thank you so much, Ms. Battle. All right, today's the day and time scheduled for a hearing in this matter. This is an action to terminate the tenancy based on non-payment of rent.
Yes, Your Honor. I object to these proceedings moving forward because, like I said, I do have a verified petition in emergency motion for injunction in the U.S. District Court, which is the case number 25-CV-11233.
Thank you, Ms. Battle.
And like I said, this court has not put on the record of their jurisdiction. There's nothing on the record, and it stands. Every notice that I've sent is unrebutted, which stands at law. And jurisdiction is a threshold issue that we shouldn't even made it this far without discussing proper jurisdiction.
All right. Anything else, Ms. Battle?
As of right now, no.
Okay, thank you.
But I object to these proceedings in jurisdiction, subject matter, and personal.
All right, your objection is noted for the record. Ms. Battle, I've already ruled on jurisdiction when we were here last time. We will be proceeding today. The court does have jurisdiction. Mr. Fantera, and Ms. Battle, do either of you have?
I object. The court cannot declare its own jurisdiction to respond to.
If you keep interrupting me, ma'am, you're going to get held in contempt of court, and the court does have contempt powers, so are you in jail?
I interrupted you. Okay, that's all.
Your Honor, I want to point out also that Judge Vandenberg actually addressed this issue last Wednesday and said that the 14B District Court and Your Honor does have jurisdiction over this matter. So not that it needed to.
May I add, Your Honor? Yeah. She also said that she was not aware of the things going on, so she just went off for anything based on what he just said. She said any law nor facts, just as you don't, of why you have jurisdiction. And it's no order that has it back yet, to be clear.
All right, thank you. Again, Ms. Battle, this court has jurisdiction and we will be proceeding today. Mr. Fantera, well, actually the both of you have an opportunity at this time to do any opening argument that you want to make. So Mr. Fantera, I will start with you. Do you have an opening statement?
I'll waive my opening statement, Your Honor, and just get right to the evidence.
All right. With respect to service, can you please put on the proofs regarding the service in case there is an appeal?
Say that again, Your Honor.
Can you please put on proofs regarding service in the event that there is an appeal?
You mean service of this lawsuit?
Yes, on Ms. Battle.
I believe that she was served by court officer with Jimmy Moore's office, Your Honor. I think there's a proof of service in the file. And I don't know whether it was attached or whether it was personally served. But the court has that proof of service.
With respect to proof of service, the file indicates that Ms. Battle was served with 2 different ways pursuant to MCR 4.201D, which is she was served, actually 3 different ways. She was served with an original mailing from the court, and then a second mailing went out from the court. Second mailing was requested by the plaintiff and was sent by this court. On March 28th, there was a mailing. And then there was service by Edward Cope, who was the court officer. That service was effectuated through securing an attachment to the main entrance of the tenant's dwelling unit. And that was done on April 4th, 2025. And after attempts had been made on April 2nd at 12:40, and then April 3rd at 9:53, they finally did an attachment on April 4th at 4:30 p.m. In addition to that, Ms. Battle showed up to the court on April 9th, 2025 before the magistrate, therefore acknowledging that she had received service in this matter and that service had been perfected. Right. With respect to jurisdiction, we addressed that at the last court hearing. This is in Russell Court, which is within the jurisdiction of Ypsilanti Township. I think you hung up.
Your Honor, when she comes back, can we require her to, she appeared the last 2 times with a video. Can we require her to have video today?
Ms. Battle, are you back?
Yeah, we were disconnected.
Yes, Ms. Battle, you're back. All right.
Yeah.
What request were you making, Mr. Fantier?
I know the last 2 times that Ms. Battle has appeared, she appeared with a video, and this time she's just on her phone. Can we require her to be here by video today also?
I would have had to give
Well,
her.
the thing is like I tried to tell you all last time that the time was bad. This is when I pick up my kids.
All
So
right,
if we
then
can
we
do
can
it
just,
like earlier or something of that nature, yeah, that's fine.
then I'm okay just proceeding as long as the court is comfortable that we can swear her in when she goes to testify.
Thank you. I am comfortable. I can tell you that if I was going to require that she be here via video, I would need to give her notice of that prior to today's date. So I'm comfortable proceeding as we are.
Okay.
All right. And Ms. Battle, other than jurisdiction, which has been noted and reserved, do you have any other argument you want to make today with respect to this matter in terms of an opening argument?
Of course. So like I said, the contract has been rescinded on April 1st, and it was due to unconscionable pieces in the contract, including pieces that's wrong with the formation, as well as material breaches that's inside the contract. That contract has not been
you said
material breaches.
Oh, okay, go ahead.
Breaches, yes, within the contract as well. That was sent out and received. Well, it actually wasn't received on April 1st because at the end of the day, unconscionable pieces, their addresses are wrong and the owners are wrong on the contract, so it got sent back. But once I realized it was sent and received on April 8th, 2015, and still remains unrebutted. They have yet to unrebut it in any case that we came and talked about the contract. And by law, according to Wall versus Zendaya, the Michigan law recognizes rescissions at common law for breach, fraud, and unconscionability. Meaning, if I give notice and it's unrebutted, that stands at law. Also, I've talked on personal matter jurisdiction, in why I came in under special appearance the first two hearings, because at the end of the day, I'm not a legal person. I'm not in a legal capacity under Michigan law. I do not qualify as that person, which that person is a corporation, a trust, individual, in some type of legal entity of that nature, an association. I do not qualify as one of those people to be here and subjected to this without consent. Hence why, things were sent administratively and defaults were given administratively, because things are happening right here where I'm being deprived of due process, and I should be awarded due process by law. As the attorney stated last time we were here, he was saying that basically the burden of proof only applies in criminal cases, which is false, because the burden of proof applies in all civil cases where jurisdiction or contract validity challenged, and that's Taylor versus Bullam in 1992 in Michigan. You still have the burden of proof. The court cannot establish their own jurisdiction being based on a contract is rescinded. You have to have a valid contract to come into court about. So that's where your jurisdiction of the subject matter is at hand, because the contract is rescinded, not unilaterally, like he's tried to claim before. It is rescinded, meaning I gave you notice and it's unrebutted, just as if somebody came into the courtroom for an eviction, or if they did not come for the eviction, you'll give them a default, because what happens at law, your silence stands.
All right, thank you, Ms. Battle. Mr. Fantera, you may proceed with your case.
Plaintiff would like to call Dawn Charles as a witness.
All right, Ms. Charles, please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing?
I do.
Thank you. You may lower your hand. You may proceed.
Ms. Charles, please state your name for the record.
Dawn Charles.
And what is your position with the Ranches of Rosebrook?
I'm the property manager.
Are you familiar with the tenancy of Anise Battle?
I am.
Are you familiar with the lease agreement that she signed?
I am.
Your Honor, I submitted to the court a lease agreement dated November 12, 2024. I'd be moving for that to be admitted as Plaintiff's Exhibit 1.
Did you also provide a copy to the defendant?
I did not, because I do not have her email address. But she should, Your Honor, I should say for the record, she should have a copy of the lease, because it is, because she signed it.
Any objection?
I never received a hard copy of the lease, and I've asked for a hard copy of the lease, never received it. And as I read the lease, that was also a breach of my lease, as I was supposed to receive it and sign it in person, as they made me sign it over online. So again, the information that he's saying about the lease is correct. I'm not here to argue about the lease. As far as what the original contract was, I'm arguing about the validity of what it is now, which is invalid and void because it's been rescinded.
Thank you.
And unrebutted.
All right, given that she's not arguing about the validity of the lease itself, I will allow the exhibit
No,
one.
I've said I did argue about the validity of the lease as far as it being valid, because it's not. But I'm not arguing that I entered into a lease on or around December 6th. That's not what I'm arguing. I'm arguing the validity of the lease. So let's correct that.
You're arguing, you're not arguing that you entered into the, what are you arguing?
Like I said, I do not object to actually entering into a lease. What I thought was, yes, a proper lease or on or around December 6th. I do not deny that, but I do deny the validity of the lease because the lease has been rescinded and it's unconscionable. Yes.
Thank you. Her argument, as the objection in this case is that the lease is rescinded and therefore it's not allowed to be admitted. That is overruled and it will be admitted.
Hold on, 1 second. Hold on. Y'all gotta. Everybody be quiet. I'm sorry, I didn't hear you, Judge.
I said that your argument that the lease is rescinded is not being admitted. The lease is admitted. That objection is overruled.
On what facts of law?
The fact that I just ruled that, ma'am.
That's not a fact or a law. So let the record show that she has no
The record
no
shows
law or no merit to
everything. The record shows everything, ma'am. You don't need to say that. And please
I know
stop.
it will when I pull the transcripts, because like I said, this case is also.
All right, Mr. Fantair, you may proceed.
Okay, I want the record to show that I find it unfair that you can cut me off and use my mic whenever you feel like it. But I can't talk and have a fair hearing.
You're going to be held in contempt of court and you're going to do jail time. Mr. Fantair, please proceed.
Ms. Charles, can you, under the terms of the lease, what is Ms. Battle's monthly rent?
$1,075.
$1,075?
Correct.
Does she also have to pay utilities?
Water and sewer.
So for what months has she not paid her rent?
March, April, and now May.
So she owes $1,075 for each of those 3 months.
Correct.
Has she, does she owe the water and sewer for those 3 months also?
Yes.
How much does she owe for those months?
Her water and sewer?
Yes.
So March is 36.24.
April?
35.45.
May?
35.73.
Okay. That totals 107.42, correct?
Correct.
Are there late fees under her lease?
There are.
What is the late fee?
$50.
On what day?
The 6th.
And so she's being charged a late fee for March and April, correct?
Correct.
So the total amount that she owes is $3,225 in rent, $107.42 in utilities, which is also rent, $100 in late fees, and then she would owe the court costs of this in this matter, correct?
Correct.
Have you reviewed the work orders that have been submitted by Ms. Battle since she has been a tenant?
Yes, I have.
Are you comfortable that they were all completed in a timely fashion?
Yes.
No further questions, Your Honor.
Thank you. Ms. Battle, do you have questions for Ms. Charles?
Yes, I do. So the first working order, are you able to disclose, or do you know firsthand what that was?
Your first work order was your shower water wasn't hot. You had some screws in your hinges that weren't secure. And when the water was turned on in the tub, it comes out of the shower as well.
Okay. So how do you define complete? How is that work order complete?
Well, that was the work order you put in. The notes for repair are that the diverter for your hot water was repaired. Our construction company fixed the tub faucet that had came off, and we installed new screws in hinges on the door.
Right. So do you have anything that the actual construction company came, because nobody came? Because even if you go on to the next 3 orders, that's also listed as an issue because it was never addressed.
Well, the next work order
Is that
after that
correct?
was actually December 26th, and it says the door that was repaired, the screws were still not right, so we put new screws in it, so that wasn't a work order about the tub. The one after that was January 28th, and that was about hearing animals in the attic, and we installed new soffit and made sure nothing was in there. There was also one on January 27th. We adjusted your shower head and plunged your toilet and tightened a basket on your sink. There was one on February 14th that your tub was not draining and water was coming out of the faucet. We unclogged the tub and the shower head was working properly. And the last one was March 17th that your furnace was cutting on and off. And we took your furnace apart and checked all the fuses and put it back together, and it was up and operating properly.
Okay, so let's go into that more, because we might even have to subpoena the maintenance man, because this is going to become an issue. So when you say that you came into my bathroom and screwed the shower head, what would be your purpose of doing that? Because what was my request? My request was that it was still, the water was still coming out of both faucets at the same time, which have not been correct because you have not gotten a contractor out here. A contractor has not came out to my house about that. And let's go on to the heat, right?
Miss Battle.
I'm sorry.
You can't testify now. You can ask her questions. You will get a chance.
Okay, I'm gonna ask her
Contractor
a
was
question.
in
You're right.
the apartment between December 15th and 16th because the
Wait a
work order was
second. Wait,
closed.
no, everybody stop.
Wait.
There's no question
You
on
said I
that.
had to form it as a question. I apologize.
Okay, go ahead, Miss Battle.
Okay. So you're saying that a contractor came out, you said December 16th?
Correct.
And what contractor was that? The contractor that did the job?
Correct.
Okay. And when that contractor came out, what did they say that they did?
Repaired the tub faucet that had came off and repaired the tub diverter.
They
for
repaired
hot
the
water.
what that came off?
The faucet for the tub
One more time. Uh-huh.
and the diverter for the water.
Right. Okay. So let that address that the faucet pushing out and the diverter, that doesn't address the issue of the plumbing, which really, when I had somebody come out, they said the wall has to be taken down because what happened is they messed up behind it. So again, let's rephrase. Let's go on to the new one. Let's go on to the furnace. So when they came out for the furnace, and they came out to fix it the first time, what were their results from that?
I only have one work order for your furnace. They took it apart, checked the fuse, put it back together, and it was up and running. They cleaned it and put it back together.
Okay.
The furnace is new.
So no, it was 2 work orders. One was done in the middle of the night. Early in the morning before they came into work.
Your Honor,
So I just wanted to be clear. So you don't have that work order for the morning? I'm asking the question.
1 second, there's an objection.
Your Honor,
Oh, you said it was an objection?
Can you listen to it, Ms. Battle?
I can hear him now. You say he had an objection?
Your Honor, I want to object. We're getting into the weeds here. I mean, you don't have a right to withhold rent or rescind a lease because of something small such as a tub faucet. And so, you know, we're getting into whether somebody actually came out and fixed it or when it got fixed. And it just seems to me that this is irrelevant to the proceeding that's going on today.
Well, it's object because it's not irrelevant to the proceeding because it's part of the reason on why I caught out the breach, because at the end of the day, I kept trying to get somebody to come out to fix these things that are not fixed. Heat is a major thing. It's been cold. I still have a heater in my house because they haven't came back and got it and fixed it like they said they were going to. You get what I'm saying? It's still unconscionable things in the lease regardless. So everything about what I am arguing here is valid because I do have the right to rescind the contract based on breaches of the contract, just like you can come here on a quote unquote breach of the contract. It's the same thing. Why do I not get the same right and to hear what's going on so she can hear what's going on?
Your Honor, we'll be more than happy to, the purpose of rescission, as the court knows, is to put the parties back in the same position they were before the contract got entered into. We will be more than happy to rescind this contract and basically have Miss Battle pay what she owes through the date of move out and terminate it so she doesn't have any more rent owing after move out. The problem is what she said to Judge Vandenberg last week, and I believe what she believes, is that when something gets rescinded, she is allowed to live there until she finds a new place. And that is not the law. We are more than happy to rescind this, to do away with this contract, let her pay her balance through the date of move out and terminate this contract so that she can move on and we can move on. But what we can't let her do is to live there forever without paying rent.
Well, let it show that by law, by contract law, if the breach is on your end, if you want to comply to it, like I said, because I did rescind it, and the breach was on your end, and it's rebutted on your end. And by law, under the landlord and tenant, it is called constructive possession. When you are in breach of a contract and I'm not at fault, I am allowed under equity and law to stay in a place. It's called constructive possession. Constructive possession. The breach is not on my end. It was on your end.
Miss Battle, that's not the law, ma'am. That is not the law. Absolutely not at all. And ma'am.
Okay, so then if that's the case, if he wants to call out the breach of contract, then he's making it an uneven deal. Okay? So if he wants to say that he wants to accept the breach, then he has to accept the damages that come behind it. Because there's damages if I have to relocate on something that's not based on me. That's unfair. And that is that's unfair in bad faith.
Your Honor, I'm not trying to be unfair. All I'm trying to say
the breach is not on me. The breach isn't on me. So if the breach is on me, I will understand what you're saying completely. The breach is not on me, so I should not be held liable for y'all breach.
Yeah, but you're the one that wants to, Your Honor, but she is the one that wants to rescind. So it seems to me that she can't have.
I want to rescind based on the unconscionable contract. And what does my rescission also say? If it says it, if that's the case, if you all want me to leave and you don't want me to have the constructive possession, then you ought to be paying for my relocation because it was your injury to me.
Can I say something without being interrupted, please?
I want you both to stop talking for a minute, please.
Go ahead. I'm sorry.
So, first of all, if you want to talk about whether a contract can be rescinded, that is not typically what happens in a landlord-tenant. That's in a standard contract situation. However, if there is, in fact, a situation where capital is for you to get some of your monies back. That's not something where you get to just rescind the contract. That's why all of this is the wrong procedure. However, Mr.
I'm sorry.
Please. Mr. Fantera.
You're saying something about getting your money. I need you to go back a little bit. It's breaking up really, really bad.
So you're
Because I
entitled,
can't hear you clearly.
if in fact the court were to find that, for instance, the property was not habitable, like there were enough repairs that were done so that the property was habitable, we're not gonna be able to make this out because of the children in the back. My recorder is saying she can't make it out.
I'm trying to make it out too, and it's just like breaking up a little bit. That's why I mean, I tried to tell y'all that this was not like a good time for me at all. Remember, you had got his time, and when I went to go say my time, you cut my mic off, and I was literally trying to tell you that I cannot. It's 3 o'clock is just not a good time. I'm getting my kids out of school. I don't have help when it comes to getting my kids out of school. So, yeah, but we can continue to try. We can just try to go for a morning time. I can do morning time.
Tim, I have
Where
on the mornings.
you don't
have to figure this out. And if you don't figure it out, then the repercussions will be against you. You're gonna have to figure it out.
Well, hold on. I am trying to figure it out. I wouldn't be here if I wasn't trying to figure it out, or if I wasn't trying to, you know.
I grant you that. I agree that I agree with that. But I have criminal dockets every morning. We don't have morning docket.
You said what about a warning? Hey, stop. Hey. You said what about a warning?
I said we have criminal dockets in the morning, ma'am. Is what I said.
Yeah, I can do it in the morning.
That's not what I said.
Oh, I'm sorry. I'm sorry.
Hold on.
Hello? Y'all can't be that loud. No, Leah, for real.
Mr. Fantera, this is not working. It can't be recorded properly because of the background noise. I can't finish this today. Are you available on the 16th at 9 in the morning?
I am, make sure my witnesses are Dawn.
Yep.
Ms. Battle, are you available at 9 in the morning on February 16th?
May 16th, Your Honor.
May 16th. I'm sorry, I'm discombobulated.
Yes, 9
a.m. works?
Yes, 9 a.m. is perfect.
16th at 9. We'll be back here again.
Your Honor, can we require, since I asked before and you said you didn't give notice, her to be by video Zoom?
Yes, Ms. Battle, can you come via video Zoom, please? Ms. Battle, you're muted.
I'm sorry. I keep trying to mute it because I think that's why I keep muting me because of my background. But I say yes, that's fine.
Okay, thank you. I appreciate it.
And I will also mail copies of all of the exhibits that I submitted to the court to Ms. Battle so that she has them beforehand.
Thank you. We'll see y'all.
I appreciate it, David.
See y'all May 16th at 9.
Okay. Thank you.
All right, gentlemen, this is a citation that was issued on April 2nd of this year on Blue Star Highway there, City of Saugatuck. It's a speeding citation on an actual 55 and a 35. However, it was only written as 6 to 10 over. Mr. Crabtree, you are here on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
I want to contest.
All right. Then even though I cannot see you, I'd ask that you raise your right hand, same way the deputy is going to raise his right hand. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes, sir.
I do. Yes, sir.
All right, Mr. Crabtree, it makes a lot more sense for me to start with deputy. He has the burden to establish to me why you were issued a citation in the first place. But then after that, you'll have an opportunity to either ask questions or testify on your own behalf. And with that, deputy, you want to pick up the narrative somewhere it makes sense, explain the issuing of this citation.
Yes, Your Honor. So when I issued the citation, or I should say before I issued the citation, I was running stationary speed enforcement near the intersection of Blue Star and Lake. I was facing southbound on the eastern side of the roadway, Blue Star Highway, just north of Lake Street. As I was doing so, I noticed the suspect's vehicle traveling northbound across the bridge that connects the cities of Saugatuck and Douglas. I noticed that this vehicle appeared to be traveling much faster than the posted speed limit of 35 miles per hour. I then activated my front-facing stationary radar device, which was reading solely the traffic that was coming at me and no other traffic. The defendant's vehicle was the only vehicle in this zone at this time. As I activated it, it showed me that the defendant's vehicle was traveling 55 miles per hour in the 35. Upon seeing this, I turned around my patrol vehicle and followed the defendant's vehicle until I was able to catch up with him on Old Allegan Road, just east of Blue Star Highway, so about a mile away. I explained to the defendant why I was stopping him. He did not agree with me. Eventually, him and I came to a bit of an agreement. We calmed down a little bit, and I only ended up writing him for 45 and a 35 as opposed to 55 and a 35. I should also note that my radar is calibrated at the beginning and end of every one of my shifts.
All right. Mr. Crabtree, what is it you'd like to tell me?
My wife is also here, Amber Crabtree. It's funny because I asked him if he had video because I had my cruise control on, and he also said that he couldn't see the proof of insurance. Well, I got enough of those tickets to know that that's automatically on your guy's computer. I just got tagged. I didn't even need to show my proof.
Sir, you don't have a ticket.
I don't know what the deal is.
You don't have a ticket for no proof of insurance, sir. I just need to know what speed you think you were traveling. I have testimony you were traveling 55 and a 35.
No, I wasn't. Me and my wife were just talking about my speed, and I was telling her I had it on cruise control. That's why when he walked up, I asked him if he had it on video. And then he said that he needed my insurance. I said, you got it on your computer. He said, no, I don't. So he lied to me.
Anything further you'd like to add, sir?
And my wife was right here as witness.
Yep, I was there, and he was not traveling that fast, sir.
All right. Anything further you'd like to say?
Nope. I've gotten
right.
tickets
Well,
for
sir,
speeding. If I was, I would have just pled guilty and paid it. But this time I wasn't.
All right. So, sir, the evidence I have before me is that the deputy has you going 55 in a posted 35, as evidenced by his testimony and his radar that he says was in proper working order that day. You just said, no, I wasn't. And your wife said, no, you weren't. I have no evidence on your side of you going how fast you think you were going. So I would have to decide that I find that you were, that there is enough evidence here to find you responsible on this citation.
That's unfair.
What's that?
That's not fair. That's very unfair. No,
Sir,
I was not
I
speeding.
gave you
I
an
had my cruise
opportunity. You
control
didn't
on.
even tell me what speed you were going. You just said you had your cruise control on. That doesn't help
At
me at
40
all.
miles an hour. I was going
That's the
40
first
miles
time
an
you
hour.
just said that, sir, after proofs are closed.
I'm sorry. I thought I said that.
No, sir.
I apologize.
And your wife
sir.
didn't
I apologize.
either.
I thought
And
I said I was
even
going
asked
for it.
you, I asked you and your wife multiple times if there was anything further you'd like to say as far as your testimony. You never provided an alternative to the deputy's testimony that you're going 55. So here's what I will tell you. Because you had an informal hearing, you do have a right to go to formal hearing. Formal hearing is in front of the district court judges with the prosecutor's office. I shouldn't give you legal advice, but you would need to testify to a speed less than what you're accused of going to have any chance of winning. But in order for you to go to formal hearing, you'd have to do two things. One is you'd have to ask to do that within 7 days of today's date. Your window of opportunity to continue to contest this ticket closes after 7 days. And two, you'd have to come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights on appeal?
I do. Now, why do I got to go pay if I'm innocent till proven guilty? I have the right to appeal.
Because, sir, at formal hearing, well, first of all, this is not a criminal matter, sir. It's not. We don't talk like innocent or guilty. It's a civil infraction. But in order, the formal hearing includes subpoenaing witnesses. The prosecutor has to be present. There's a certain cost to the court in order to hold a formal hearing. And for you to set up a formal hearing and then just not show up costs the court, like I said, an amount of money. So they make you post a bond to guarantee your appearance at formal hearing. The bond is the same amount as the fine. If you win at formal hearing, you get that money right back. It's only if you would continue to be found responsible, they would use that for fines and costs.
I would have taken responsibility if I had been speeding. I've had enough tickets, and I'm not, I'm just saying that. I know I have my cruise control on. I was just talking to my wife about my speed.
Even the cruise control that you told me is still speeding, right?
It's 40 miles an hour.
40 to 35 is 1 to 5 over.
And you're allowed to go 5 over.
Well, not if you get a ticket. My job is to decide if you were going a certain amount over the limit. If you were written for 5 over and you're going 5 over, you would be found responsible. I don't want you to think there's a certain amount of speeding you're allowed to do.
I've been told that it is legal to go 5 over. I mean, I can look that up. I
don't know who told you that, sir, but I can guarantee you that's not correct. 1 mile over is still speeding if the officer were to decide to write you a ticket for that. But we're all set here. I'm going to release parties. Thank you.
Hello.
All right. On the Google Pixel 9, are you Miss Aguilar?
Yes, I am.
Okay. This is a citation. It was issued on April 4th of this year on US 131 there in Gunplain Township. This is a speeding citation on an actual 88 and a 70. However, it was only written as 6 to 10 over. So, Ms. Aguilar, you are here on this 6 to 10 over speeder to do one of three things. First is you could admit responsibility to the citation. Or two, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened. Or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
Number 2.
Okay. And what is it you'd like to tell me?
Your Honor, I'd like to explain what happened that day when I received the citation. I was in the left lane passing a slower moving vehicle, and I did increase my speed briefly in order to pass and merge back into the right lane. But I was not driving recklessly. I was pulled over shortly after by the officer who was originally traveling the opposite direction and made a U-turn on that highway. Given the circumstance and nearby traffic, I'm not even sure the speed he clocked was mine. I thought I was pulled over because at the time I did not have my license plate attached to the back. It was in my front seat. So I was not aware of getting pulled over for speed. I just thought it was my car needing the identification. During the stop, the officer did conduct the conduction or the interaction made me uncomfortable. He questioned several times about alcohol and drugs, despite there being no evidence. He kept pressuring that, so that kind of made me like really scared. But he did peer through my windows of the car. The car is brand new, so there's really nothing there. I've never been in trouble before. I have a really good driving record. I do take driving seriously. I lost my brother to a reckless driver. I'm just asking the court to just please take the circumstances into consideration when reviewing the citation.
Okay, well, ma'am, if you contested the citation, I would hear evidence and decide whether or not you were responsible or not. You're admitting responsibility to the citation, so I can't change the nature of your ticket. Now, lots of times what people, when they come in here, what they're concerned about is getting points on their license. Do you know what I mean by that?
Yes.
Is that what you're concerned about?
I'm concerned about the points and the amount. I'm just concerned about it all, Your Honor. Like, this is my first ticket I'm trying to fight.
Well, first of all, the officer didn't write you a ticket for going 88 and a 70. The trooper gave you a break and wrote you the second wimpiest ticket he could write you. I think this is only a 1-point ticket. But here's what I'll explain to you about points. I'm not going to give you points on this. The trooper didn't give you points on this. Points don't come from us. All right, that fines and costs is the only penalty. Now, points come from Secretary of State. Secretary of State court, two different animals. They can't tell me what to do. I can't tell them what to do.
Okay.
But here's what I would say about points. First of all, points die a natural death every 2 years. So if you want to, just outweight this point and it will go away after 2 years. But maybe more to the point, if this is what concerns you, is there's a way for you to get rid of that point. But all I can do is explain to you how to do it for yourself. I can't do it for you. But are you curious?
I am curious. I'm also curious to know if I don't know, like this is my first time. I'm not sure if I'm doing this right. Trying to fight it. I'm just agreeing with the officer. I honestly don't even remember that day how much speed I went, because like I said, he was traveling opposite and there was multiple cars and he was behind another car.
Here's a couple of things I would tell you. First of all, we do not mind people coming in here and essentially saying, look, I don't know what I'm doing, but I want to see what happens. And this is what I want. The first thing first is, when you're telling me I thought I got pulled over for no plate, that doesn't make a lot of sense, because the trooper, if he's coming at you the opposite way, he wouldn't know you didn't have a plate on the back of your car. So to spin around on you and pull you over is probably for a moving violation.
Well,
the other thing is, what's that?
I am so sorry, Your Honor. You can finish. I'm so sorry. I didn't mean to cut you off.
The other thing is, most of the people don't realize just how far away that they're getting radared by that. So in other words, it would be the opposite direction radar in the front of the trooper's vehicle. Yes, you likely got radared when you were passing someone, and that's why it was 88. I will tell you this, though. The actual law is you still can only go up to the speed limit to pass somebody. That's how slow somebody's supposed to be going for you to pass them. You were allowed to go up to 70 to pass, but passing is not an exception to the speeding rule. You still only can go the speed limit. But like I said, if you don't remember how fast you're going, the trooper's testimony would have been, of course, that his radar said 88 and that he checked his radar. So if you had a hearing, I likely would have found you responsible, but here we are sort of on the back end. But here's what I can tell you about points. On the Secretary of State's website, they have something called the Basic Driver Improvement Course. It's a safe driving quiz that you take online. I can't imagine it's very hard. It just takes up some of your day. Here are the 3 rules for it. You can't be a CDL driver, right? That means driving the big rigs. You're not driving the big rigs, right? 2, you can't be carrying more than 2 points on your license already. You wouldn't be, because you said I got this good driving record before this. And 3, you can't have taken this test before to get rid of points, which I don't imagine you have before. You don't get to keep using this trick, but if you go to the Secretary of State's website and you take that Basic Driver Improvement Course, the carrot they give you is they'll remove the points from any one moving violation, which is what this is. So you have the opportunity to make it 0 points, but you have to jump through those hoops yourself. I can't do it for you. Does that make sense?
That does make sense.
So otherwise, all that's left for you to do is, for us here on this ticket, is to call the district court to make arrangements to pay that fines and costs. And the point will either go away after 2 years, or you can make it go away if you want to take those steps. All right?
All right. I do have a question. If we're able to pull the footage of that day, because the officer did say his camera was on. And when I was passing the car, he wasn't behind me like right away. It was a few miles down the road, and then he went behind me. So that's why I thought it was my license, not
I will let the trooper correct me, but when they say that, the camera comes on when they turn on lights and sirens. So it wouldn't have been on coming at you when it caught you speeding, and then he looped around on you, and then if to pull you over, he put his lights on. That's the camera footage he'd have, not of the speeding incident.
Can he pull that's so difficult. That's since there is no proof and he said I was going 88 and I'm just agreeing to it, what do I do, Your Honor?
Well, you could fight the ticket, but like I said, I know what his testimony is going to be, and your testimony is going to be, I really don't know how fast I was going. So
but
there's not much.
You just said he didn't have. You just said that there was the radar he can't prove that radar was my car when he was trying.
No, ma'am, that's sort of a misunderstanding. Proof comes in many different forms, right? Now, if he had video footage, right, that would be one type of proof. But his testimony is in fact proof, because he would be under oath and he would testify as to your speed. That is proof.
And for mine, can I be under oath and testify?
You would be under oath as well, but your proof would be, I really don't know how fast I was going. I just don't think I was going that fast. Which one of those two proofs sounds more firm and that I would go with at the end of the day?
Well, I would go with mine because the officer was really traveling the opposite direction. And I know I'm a safe driver. That's why I said I don't know. And that's why I was so confused when he pulled me over, was because
Ma'am, would you like to have a hearing?
If that's possible, yeah, I think I would.
All right. So, Trooper, if you would go ahead and raise your right hand.
Yes, sir.
Ms. Aguilar, go ahead and raise your right hand.
I apologize about the video as well. I'm having connectivity issues.
That's all right, as long as I can hear you. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth?
Yes, sir. I do.
Yeah.
All right. Ms. Aguilar, it makes a lot more sense for me to start with the trooper. He has the burden to establish to me why you were issued a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify on your own behalf, all right?
Okay.
And with that, Trooper, if you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation.
Yes, sir. I'd like the court to know, to start off, that I'm a certified MCOLS radar operator. The unit that I was using on the day that I issued the citation is certified by the state of Michigan radar unit. The radar unit that I was using is affixed to my patrol car dash. And I verified the working condition of the radar at the beginning and end of my shift, as I do every single day. On this specific day, on April 4th of 2025, approximately 7:49 a.m., in the county of Allegan, township of Gunplain, I was actually working stationary radar patrol in the median just north of 106th Ave. I was facing oncoming traffic, so southbound traffic, while my patrol car was facing northbound. While doing so, I activated my stationary radar, opposite direction radar, at which time I observed a white Nissan passenger car pass through the operational range or beam of my radar. At this time, I observed the vehicle traveling 88 miles an hour in a 70 mile per hour zone, and subsequently initiated a traffic stop of the vehicle and identified the driver as Ms. Aguilar. And after a brief investigation, issued a citation for 6 to 10 over rather than the 18 over that I observed her traveling. I would like the court to know that my radar unit was free of any obstructions. The vehicle that I was tracking was the vehicle being driven by Miss Aguilar. I know that because as the vehicle passed through the operational range of my radar, I heard an audible tone corresponding with the speed. And then once the vehicle passed through the operational range of my radar, the tone ceased to exist. So I'm confident the target vehicle was the vehicle that I stopped. And the driver of the vehicle was the driver that I issued the citation to.
And Trooper, I'm just going to ask you a question or two because I know that Ms. Aguilar is interested in how this works. You testified that you checked your radar at the beginning and end of your shift. I'm assuming what you mean by that is you checked it against your separately calibrated speedometer.
Correct. So we're required at the beginning of beginning and end of every shift. It's actually on our program or on our daily system where we check and track the condition of the radar to make sure it's working in proper condition, that everything is accurate, and that there is nothing is inaccurate, nor is it not functioning properly.
And then let me ask you, Trooper, if during the check at the beginning of your shift, it did not check out, what would you do?
I would not be able to conduct radar. I would have to immediately contact Wheels or our technicians to come immediately and fix and calibrate and make sure to get the radar in working condition. It's actually, we are not allowed to use that radar unit if at any point in time it is not in proper working condition.
And then if it was working at beginning of shift, you wrote tickets all day, and then at your end of shift, there was a problem with the radar, what would you do with the tickets you wrote all day?
They would immediately have to be voided.
All right. And so, Ms. Aguilar, I'll turn this over to you now. So it's your turn to either testify on your own behalf or ask questions of the trooper.
I would like to get proof. I feel like I should see the video to testify for the proof.
Ma'am, the enormous amount of evidence that he just testified to is the proof, just so we're clear.
Yeah, he said that he was clocking south, but I saw him while traveling before passing. He was moving and making a U-turn. He wasn't sitting still. He wasn't. That's why I'm really confident that there was other passing vehicles. And he said that he's confident that the radar did read, and that's not technically proof. Like he's just verbally saying confident. And then he was behind a different car before.
No, ma'am. I'm gonna sort of crawl through this because if there was somebody else behind you, we wouldn't do this. But I want you to leave here understanding what happened.
Okay.
So what he testified to is he's literally just sitting there with his radar on, right? So to make sure that the radar works correctly, in the beginning of his shift, his radar has to check against a separately calibrated speedometer in his vehicle and come up with the same reading. If it doesn't, he can't use the radar all day. Then he uses the radar all day, and he does that check at the end of the shift too. And if it's not working at the end of the shift against his separately calibrated speedometer, he would just void all the tickets that he wrote.
Right.
So the first thing he said is visually he sees your car, right? Now we would let back in the old days, you'd let officers or troopers guess at speeds because this is what they do all day and they're pretty good at guessing speed. But we don't let them say how fast you're going. But we do let them testify that they think this automobile is traveling above the speed limit of 70 miles an hour, which he did. Okay. Then what he did is get you with his radar, right? So he knows that you're the car in the radar because it tones out. In other words, it makes an audible tone. And the audible tone changes in pitch depending on how fast it goes. So he also knows if that tone doesn't match the number he's seeing, something's wrong. Okay. And then once your car is out of the cone of his radar, the tone stops. That's how he knows it's sort of your car. Then he sort of flipped around on you and pulled you over. So he actually has testified 3 different ways that you are traveling well above the speed limit of 70. And what you're telling me is, I don't know how fast I'm going, but I just don't think I was going that fast. Now I have to pick one of those sets of evidence, right? Either your evidence, which is your testimony, or his evidence, which is his testimony. And I don't have to find beyond a reasonable doubt. You've heard that before, right? Because this isn't a crime. The standard for this, because it's a civil infraction, is you likely did it, 51%. So when I weigh all his evidence and testimony versus essentially the lack of evidence and testimony on your behalf, of course I would find it is more likely than not that you were actually speeding. You were actually going faster than the ticket you were written, but you were at least going 6 to 10 over. And that's why I would find you responsible. If you're searching for more than that, or that doesn't feel like a sufficient explanation to you, I don't know what else I can do for you, man. That's how this works all day, every day.
I understand, Your Honor. Is it possible confirmation from his radar to make sure that it was working accurately that day for me?
Well, I
Like I
mean,
said,
I could have him testify to that, but we're gonna wrap things up here. Every, I think 90 days or so, what is it, a tier 3 operator checks the radars, and then every 120 days, a tier 4 operator checks all the radars of the car. And if there's any problem with any of the radars, they take those out of order. And there is some sort of maintenance logbook that the state police keep for that. You probably could subpoena those records or ask at a formal hearing that somebody would bring those records in. But at informal hearing, I would not expect the trooper to be familiar with those records at this state and time. Just know that there is in fact a method of continuously checking these radars that if there are problems, they're taken out of circulation. So that they're in circulation is sort of the prima facie evidence that against that set of checks, they are working.
thank you, Your Honor. I just want you to
sense?
that I wasn't driving recklessly. I was just passing. I do apologize.
Ma'am,
if I'm unaware.
reckless driving is actually a crime. There is a whole
Yeah.
charge for reckless driving. That's not what you have. You just have a charge of speeding, like
Yeah,
lots
that's
of
what I'm
people do.
Take into consideration if the ticket can be waived because I am a responsible, good driver.
And ma'am, here's the problem, right? If what we did was judge everybody who gets a ticket on whether or not they're a good driver or not, that would be incredibly unfair. So bad drivers are just automatically responsible for their tickets because they did it in the past, or good drivers couldn't possibly be speeding because they've never got a speeding ticket before. That's sort of not, I mean, it's scary that that would be how the legal system works, right? I would judge this circumstance just on this circumstance, this time frame, and the facts that are presented before me, which is exactly what we did. Now, as far as getting a break, you did get a break. You got a break on the side of the road where this trooper decided to write you a ticket that's a third less than what he could have written you for, right?
What could he have written me? I don't know what he could have written me for because.
Well, ma'am,
like,
if you're going 88 in a 70, how many miles over the speed limit is that? 18 miles, right?
well, that's what he's saying, and I was agreeing. So obviously, I have to own up to that.
No,
So,
ma'am,
yeah.
even if you, no, we stopped doing that. I didn't take it that you agreed. We had a hearing and I found clearly that you were going 18 miles over the speed limit. He did not write you a ticket for that because that's a 15 to 20 over. That's not what you're here on. That's not what I just found you guilty on. I found you guilty on a 6 to 10. He could have written you a 10 to 15 and you would have been responsible on that. He could have wrote you a 6 to 10. He could have wrote you a 1 to 5. He not only gave you a break 1 down, he gave you a break 2 tickets down. And you're still here just saying nobody gave you a break, right?
No, you're misunderstanding me because I'm not aware of breaks and tickets. This is my first one. So I hope you understand that I don't know that that is a break. But thank you for informing me about that. I'm here to
Yes.
fight it because I was just speeding to pass a car. That's it. That's all, Your Honor. And that's the break that I was looking to get. If I'm accused of speeding, I apologize. I was just passing a car in the left lane and got back over. He then was traveling behind a different car, turned his lights on, then came to me, and then I pulled over. Like I said,
it takes a while for him to catch up to you, right? Because you're going
he didn't take a
70
while.
something miles an hour and he's going no miles an hour. He has to turn around and come after you. Takes a while. But one more thing, Miss Aguilar, because you had a contested hearing, you now do have a right to go to what's called formal hearing. Formal hearing is in front of the district court judges with the prosecutor's office. But to go to formal hearing, you must do 2 things. One is you must ask for that within 7 days of today's date. Your window of opportunity to contest this further closes after 7 days. And 2, you must come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights on appeal?
Yes, I do.
All right, then we're all set for what we need to do here today. I'm going to go ahead and release parties. Thank you.
Thank you, sir. Have a good day.
You too.
Hey guys, it's an absolutely beautiful summery day. I still have a little bit of a head cold. So much so that yesterday I was that sick that I actually made this video yesterday and forgot to upload it, first of all. And second of all, I accidentally deleted all the files where I'm talking. So I'm going to make it fairly short and sweet. So basically, we have this video here where this young lady essentially just crashes into a guy, straight up just crashes into him, doesn't want to accept responsibility for it in any capacity whatsoever, blames the fact that the sensors in her car didn't alert her to it. Thinking back to what I said yesterday, was something to the effect of, you shouldn't be relying on those sensors, they're just there to help you out. Anyway, I hope you enjoyed the video. I'm trying to stay out in the sun a bit today to feel a bit better. I'm starting to get there. My voice was pretty much gone yesterday, which probably is a relief to a lot of people. But anyway, lads and lassies, thank you so much. Make sure and hit that like button. Have a great weekend, and we'll catch you all in the next one. Sláinte.
Zali, you were cited on the 6th day of April, 2:15 in the afternoon, Woodward and Buckingham, changing lanes without due care and caution. The options you have today are three. You can admit responsibility or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Deny responsibility. Would I be able to speak to the officer in a breakout room?
No.
Okay. I would like to deny. I'm sorry.
This is the date and time set for the hearing.
Okay, I would like to deny responsibility.
You'd raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
I do.
Yes. The officer will testify first. Please.
Yeah, Your Honor, on April 6th of 2025 at about 2:17 in the afternoon, I was dispatched to a property damage accident or a traffic crash involving this Buick Encore driven by Miss Pizziali, is it?
Yeah.
During which it was found that she made a lane change over to the right in a lane that was occupied by another vehicle, essentially sideswiping that vehicle. And at that time, both drivers had admitted to me the same thing of what had occurred.
Ms. Pizziali?
So there are a lot of things that happened during that situation that are confusing to me. I did turn onto Woodward going towards Buckingham, but I would say that I'm a very cautious driver. And when I made the turn, I did recognize that there was enough space between me and the cars, like coming, I'm not sure what direction, but coming toward where I was headed, for me to feel comfortable to turn onto Buckingham. As far as I know, I didn't register that that car was separate from the pack or closer to me in any way. And he was behind me the entire time. When I was getting over into the lane, my turn signal was on the entire time. And my car has safety features that recognize that, if someone's in front of me or behind me, or even in my blind spot, to signal to me to stop or to not make that motion. And none of those signals went off at the time of when our cars hit each other. And so I'm just a little bit, I was, unaware that he was in where he was. And when we hit, my car was going this way and, his was coming this way. And I genuinely don't know, he was behind me the entire time until he wasn't. And then I'm not sure if he, was trying to get around me. He saw my turn signal on and didn't, I don't know how he got there, to be completely honest with you, because
were you in one lane and were changing into another lane?
So I was turning from, I don't know the directions, but I was in a turnaround, right before Buckingham Avenue. And so I was, crossing over to get onto Buckingham. I'm not sure if that makes sense.
So
I wasn't driving in the same direction as the man. I was in a
so you're doing the Michigan left, so you went from one way on Woodward to the other way. Correct.
But okay. Buckingham was almost right across from that turn. So I was just kind of moving, through the lanes with caution. And I'm not sure if he was trying to get in front of me or like trying to, pass me as I was, trying to get onto Buckingham. But I was aware of my surroundings. I had my turn signal on, and none of the signals in my car, told me to stop, and neither did anything that I had registered previously to make that turn. So I'm not
What about looking where you were going?
I was looking where I was going. I was, and
Did you see the car?
that is what is confusing. Like, I'm not sure, I don't know. He wasn't, I didn't
Well,
register.
Scotty didn't beam him down.
I'm sorry?
Scotty didn't beam him down.
I'm not sure.
I guess I'm dating myself with Star
I'm
Trek.
sorry.
But the bottom line here is that there was a vehicle in the lane that you were going into that you didn't think was there.
Right. And I didn't see, like, he was he was far behind me from what I registered for me.
And yet the two sides of the cars were in contact with each other.
So the front of my car, and the back of his car. So as I was like turning, I don't know, I guess as I was turning, like my car and the back of his car kind of hit like this. And that was so obviously, like, it looks like my car hit his car, but he wasn't, like, I had no. And I know it's hard for me to explain because it, like, the way that our cars hit makes it look like I like totally hit him and I wasn't paying attention, but I know that not to be the case. And I had a passenger in the car.
Why do you think that's not the case?
Because I am a cautious driver, and I especially driving on Woodward, a 4-lane highway, does make me a little bit nervous. And I know that I would not, and I didn't feel comfortable turning until I knew that all of the cars, like, until I felt safe enough to turn onto Buckingham without, getting in the way of other cars or other cars, cutting a little bit too close to me. I was waiting in the turnaround until I felt safe enough, and I did feel safe enough, and somehow he came and our cars collided. I don't know if he had maybe turned onto Woodward at like around the same time that I was turning onto Buckingham. I'm not sure. But
Would it
from my
matter?
understanding, he was
Would it
not in
matter?
my blind spot. He was not in front of me. He was far behind me for me to feel safe and comfortable enough. And the passenger in my car can agree to that as well. Like, and none of the signals in my car went off.
And
Which is
when you're
why
driving, you have a duty not to turn onto a road. You were coming out of the Michigan left.
correct.
You have a duty to stay there at the stop sign until it's clear.
I agree. And that is exactly what I did.
No,
So
it isn't what you did. If it would have been clear, there wouldn't have been a crash.
that is why I'm confused. And that's why we're here today.
What's confusing you is you seem to have eliminated the possibility that you goofed. You didn't see somebody that was there.
Well, I would agree with you on that, except for I had a passenger in the car, and they were also very, like, they also are aware and a very nervous driver, and they felt that they didn't see this car either. And so that is is even more
Okay,
confusing.
the car
than
is
that
visible.
too. Right.
This is what, 2 o'clock in the afternoon.
Right.
The car doesn't have any cloaking devices. It's sitting there. It's 20 feet long. It's 6 feet wide. It's 5 feet high. It's visible.
Yeah.
There
Well,
would not have been a crash if you didn't go into that person's lane.
I'm saying that I don't think that this was my fault. I do know for a
Are you
fact
blaming
that
the other
this
guy
car-
because he's driving down the road and happens to be in a lane that you want to turn into?
I do know for a fact that he was
Do you
behind
blame
me.
him because he was where you wanted to be?
I think that this is a situation where maybe
Answer
we
my
both could
question.
have done better.
Are you blaming the other guy because he was physically present where you wanted to be?
I don't blame him because he was in that lane. I do think that I do know that he was behind me the entire time.
Ma'am, if he was
And
behind you the entire time, the front of your car wouldn't have hit the back of his.
That's what I'm saying. I don't know how he got in.
You made a mistake. You didn't see somebody that was there. It's possible you could have made a mistake, and the crash is kind of a proof of it.
Well,
we all make mistakes.
I do know.
Why can't you admit that you hit a car that was there?
I am more than willing to admit that our cars collided and that I do make mistakes sometimes, but I do not think that this is a mistake that I made.
Well,
because
causing
I
a
know
crash
for a
is a
fact-
mistake.
I'm
You didn't
sorry.
do it on purpose.
I'm sorry.
You didn't crash into the other car on purpose, did you?
I did not crash into the other
No,
car.
therefore you made a mistake.
I would say that I guess I know that it is a confusing situation in the
It's
way
not
that
confusing.
our cars.
There's nothing confusing about it. It's perfectly clear.
Your Honor, he was behind me the entire time.
Then how
And
did you hit the side of his car if he's behind you?
So I'm not sure if he was trying to get around me, but
Does
the
it
man
matter? He's
admitted.
got the right of way. You don't.
I'm not. I just. Your Honor, I am struggling. I've thought about this situation so many times, and I'm just struggling to understand really what happened. And I talked to the other passenger in the car, and she also is struggling to understand how that happened because like he was behind me until he was.
If he was behind you, you wouldn't have hit the side of his car.
But he was aware that I was turning into the lane.
It doesn't
He
matter.
was
You
aware,
don't.
and
You're not parting the waters of the Red Sea with a turn signal. You
I
turn the
understand that.
you turn your turn signal on. It doesn't tell people they have to get out of your way.
I understand that. The issue that I'm having is that when I turned onto Woodward toward Buckingham, I was very confident in the fact that I could get to Buckingham without even with having the cars that were coming, toward Buckingham have a lot of space where I wouldn't have even gotten even close to them. So that is what is confusing. I'm not sure if this man.
You're eliminating the possibility that you made a mistake. You didn't go until you were confident, but you were mistaken. If you would have been correct, there would not have been a crash.
And so that is what I initially thought as well, because I was like, this is a mistake that I made. But upon further reflection and talking to the passenger in the car with me, I realized that I really genuinely I did not make a mistake. The car was with the pack of cars that I felt safe enough to turn in front of. I'm not sure if this man had seen me coming, saw my turn signal, decided to, get around me or get past me, and then
Which he has a right to do.
happened.
First of all, you're making an illegal turn. When you make a left turn onto Woodward Avenue, the statute requires you to make the left turn into the left lane. Then you can change lanes, but you can't make the left into the second or the third or the fourth lane. So when you make a right turn, you have to make it into the rightmost lane. When you make a left turn, you have to make it into the leftmost lane. The statute requires that. But that is kind of honored in the breach with the Michigan left set up the way they are. However, when there's traffic on Woodward proceeding in the way that you want to go, or if you want to cross them, whichever way you're going to look at it, they have the right of way. You have to wait for them. You didn't. There was a crash. You caused the crash. You're responsible for the civil infraction of making an improper lane change. This idea that upon reflection, you can't see that it was your fault flies in the face of the reality of the situation, that you felt confident you could go, you went because you were sure it was safe, and unfortunately, you were wrong. Fine is 170. It's clear that you're responsible. There's no ambiguity there at all. If the officer hadn't testified, if I heard only your testimony, I'd have to find you responsible. The fine is $175. It can be paid online or by mail. Or you could drop by the courthouse and pay it at the counter if that's more convenient for you. Thank you.
Okay. Thank you.
Now in session, Judge Sam Myers presiding.
You can be seated. So this is the anti-harassment calendar. And before we get started, I'm going to take attendance, find out who's here. First of all, is Joanna McGowan either in here or on the Zoom call? Yeah, could you come on the Zoom call, ma'am? Can you do it, please? You're muted, ma'am. I'm going to need you to unmute.
Yes, Your Honor.
Hi there. So we've been contacted by the petitioner in this case, and she's unable to make it here today. So for one time, we're going to reissue the temporary, ma'am, your eyes on me, please. Thank you. And we're going to reissue the temporary order. We'll reconvene in 2 weeks, and we'll take this matter up at that time.
Okay, Your Honor.
And then I'm going to hang on just a second. I'm going to give you a date. Wait just a minute, please. It can be May 19th. At 9 a.m. And the and the temporary order was entered in this is going to be reissued. So there's a temporary still in place. Do you understand that, ma'am?
Yes, sir.
Okay, and then we'll see you in 2 weeks.
Yes, Your Honor.
And you're free to go.
Thank you.
And then, Ms. Chicas, you're not
Yes.
moving there, Chicas?
Can you hear me?
I can.
Okay.
And so then, so Ms. Anderson, before we start, and then actually I should back up a little bit further. The way the cases go is I swear in the petitioner, I'll hear from the petitioner, and I'll swear in the respondent, let the respondent responds. I may have questions for either or both parties. And we'll go from there. Over the course of these hearings, which are usually, and I expect these to be too, quite emotional, you're going to hear things you don't like. You're going to hear things you disagree with. I don't want anybody talking over the other person. Don't interrupt the other person. Don't interrupt me. And I want all comments directed to me. Don't speak at the other individual. It was less of a problem that we're on Zoom, but don't speak at the other individual. Again, I want all comments directed towards me. And so, Ms. Anderson, I'm going to start with you. Could you raise your right hand, please?
Yes.
Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. So kind of before you tell me why you need an order against Ms. Chicas, it's kind of confusing to me how these parties are related somehow. So maybe you could start by explaining that.
Well, she thinks that I intervened in her marriage, and so she stalked my life and is now married.
Okay, so hang on just a second here. So, I mean, who is she married to relative, or who are you married?
She is married to my kid's dad, who I was with for.
Okay, so hang on, just to stop there. So she's married to the father of your child.
Both of my kids.
Okay, to both kids. Okay. And so, okay, continue on. Is there any other relationship between the two of you?
No, not at all.
Okay.
Besides
So, go ahead.
Besides that, no.
Okay. So how is it you need an order? And my understanding is also she already has an order restraining you out of Superior Court. Is that correct?
Well, that was after she got served with the paperwork that I filed with the district court.
So, and my understanding is from pleadings, and you can correct me if I'm wrong, you had asked for an order against her in Superior Court, but that was denied. Is that true or not true?
It was, yes, that's true. And I didn't.
Okay, so hang on just a second. I'm going to stop you right there then. And so what, if anything, has changed from the time that order was denied and now, if anything?
Well, because I didn't realize, because I haven't dealt with the court. And so I didn't turn in a lot of evidence. And now I am going to respond back to the Superior Court because I have a lot to respond back to. And
Okay. So, but hang on just a second. I'm going to stop you again. You can't respond back to a Superior Court proceeding here. That all needs to be handled in Superior Court.
Yes, no, I know. And that's what I'm doing. Yes, that's being handled.
When is that? Is that set for hearing?
Yes, that is on the 12th.
of May. So that's next week. Is that a week
Yes,
from
next
today?
week. Yes, and I am responding back to it.
Okay. What time is that hearing set for?
Let me look. I have the paperwork right here. Let me. That is at 9 a.m. on May 13th, Tuesday.
Okay. That'd be a Tuesday.
Yes.
Okay, so Ms. Chicas, if you could raise your right hand here too, please, before I get into, do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
So, I mean, I guess, well, I mean, you have a no contact order against her. She wants a no contact order against you. You know, you all kind of want the same thing. I guess, what's your opposition to this?
My opposition is not to have something against me when I've done nothing and she has nonstop harassed me, slandered me.
Well, you did, I mean, hang on just a second. Done nothing is not completely
Okay.
accurate. You admitted to sending notes threatening to have Russia.
I do admit to sending that message. I've never contacted her prior to that or after that. And the reason why I did that, I have explained to the courts in her family case court with my husband and their kids, and also with the one with her that I have against her. I explained she reached out and stalked my son's dad, and I was letting her know to leave him alone. And I talked.
Don't lie.
Can I continue? And I talked out my ass, and I, Your Honor, I did not mean that, and I cannot.
This is a real disadvantage to Zoom because no one listens to me. So Ms. Chicas, you need to stop. You can unmute. We muted you. Ms. Anderson, you need to stop too and unmute yourself. You remember what I said at the beginning about not interrupting the other party? So here's what's going to happen here today, Ms. Anderson and Ms. Chicas. You know, problems arise when two courts are looking at the same issues and same parties from two different points of view. And so this thing has already been set for hearing in Superior Court. There's already an order in place. We're just going to transfer this thing over to Superior Court on May 13th at, what time did you say that was, ma'am?
It's at 9 a.m.
9 a.m. And then just everything can be hashed out there.
Okay, cool.
I don't want to do something here and then you're going to go to Superior Court and say, well, that district court judge did this, and then they're not going to be completely sure about it. And that's just going to make a whole lot of confusion for everybody.
Yeah.
Does that make sense?
Yes.
Ms. Anderson, Ms. Chicas?
That does.
And then, is there an order in this case?
There is.
Just, yeah, can just,
Yeah, there is.
okay. We'll do the temporary.
It would be a reissuance.
Do you need to do that?
I would need to do
Okay, you
all
can
that.
do that after.
Mhm.
Okay.
Yeah.
So this is going to get transferred to Superior Court. It'll get sent over there, and then all of your issues can be resolved by one judge in one place.
Cool. Sounds good. Thank
Does that
you.
make, you get that, Ms. Chicas? Okay. Okay, you're muted. Do you need to unmute?
Yes, Your Honor, I did. Thank you.
Okay, so you both need to attend next Tuesday.
I was like, I can.
What's that?
I can.
Okay, and then, and you are Ms. Eggers?
Yes.
Could you raise your right hand, please? And do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. And Mr. Breznovich, I'm going to hear from her. I may hear from him, and then I'll have some questions for you. And so, Ms. Eggers, how is it you need an order against Mr. Breznovich? But first of all, are you guys next door neighbors?
Yes.
Got it.
So we have we rent, and we have the main house, and he has
Mr. Breznovich, can you hear this?
Yes.
Okay, I'm gonna need you to speak a little bit louder. Please.
So we have the main house, and he has like a little AUD, kind of like they turned a garage into a studio apartment and everything.
Okay.
start off last summer, there was noise complaints and everything, and he was just blaring like gun shooting sounds.
Who was making the noise and who was complaining about it?
So we didn't file like an actual complaint because it lasted a few
So
days.
he was making the noise and you were
Yes.
complaining about it. Okay,
And
continue
then,
on.
so it's just like, it started off with just that, so we didn't actually make a complaint because it stopped within a few days and everything. But over the last few months, recently, in April, we had a lot of issues where he would ride his bike throughout our yard, and then he ended up tearing up a whole bunch of our flowers in our flower bed. And then he was pretty much vandalizing our vehicles with throwing food and everything else on all of our vehicles in our driveway and everything. And then
Well, I read that. And I think I saw in one of the videos,
it's all on videos and all on
yeah.
pictures.
And what sort of food was he throwing there?
So there was a whole bunch of like nuts and everything, and then it looked like globs of either bacon grease or something, but it's grease or oil. And it got all over 3 of our cars in our driveway. And it's stained our cars.
How long ago?
This all happened within this last month of April.
Okay.
And I sent videos and pictures of everything.
Oh, I saw.
There's like 5, and it happened like back to back to back.
Okay. So, I don't have any questions for you, Mr. Grant, right now. Basically, everything I've heard is fairly consistent with what's in the file. Mr. Bresnovich, could you raise your right hand, please?
Yes, Your Honor.
Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down, and then I'll hear from you.
Okay. So I do live in the ADU on the property. We are both renters. In front of my ADU, I have a sidewalk and a driveway. That is my access. In these videos that you see, these pictures you see, you'll see their parking situation there where they leave a void up against the house. And they leapfrog that white car by driving across my sidewalk on my driveway, and on multiple occasions kick my garbages to the ground to give themselves access. Now, I'm a disabled veteran. I just got a service dog. I usually listen to meditative music and do a lot of volunteer work. I'm not involved in just hanging out with them, dealing with them. They're constantly on that back patio right outside my front window, smoking, joking, drinking, blasting music. A significant chunk of most days. They've got extra tenants in that house. It's not just them. They have an elderly couple with them that has hard of hearing. They're always bickering and making noise. They also have a dog. Every time I step out of my house, their dog barks at me. That messes with my PTSD. I am in mental health recovery. I have been for the last 6 years. I'm going to counseling. I go to group therapies. I assist widows on farms. I work with church groups and organizations. I helped the Girl Scouts last weekend. These accusations they have are gross, disgusting, and I think they're being a bunch of divas. Your Honor.
What about it looked to me like in one of those videos, there was, it was kind of nighttime, but it looked like somebody was throwing something on the car. Was that you?
That was me.
Okay, did you throw something on their car?
A can of bacon grease.
Why would you do something like that?
Because they're driving on my sidewalk for months. They didn't show you any video of that. That's interesting.
That's not a...
They get their spot of land, I get my spot of land. They don't get to bully me in numbers.
Okay.
It's discrimination against the disabled veteran, Your Honor. I'm by myself over there. Nobody comes over. Nobody wants to visit. They hate seeing my place, and that my little tiny patio is right up against their back patio. They got 340 degrees of the property. I got 20. They can be anywhere else, but they're always right there outside my front window, less than 20 feet away, smoking, joking, drinking, throwing beer bottles in buckets. It's not their kid I'm yelling at. I told them when I first move in that I want nothing to do with them. I'm dealing with my own stuff, that I have mental health issues. I want nothing to do with them or their kids. And then they got their kid yelling at me, hi neighbor, hi neighbor, hi neighbor, demanding it. Disrespectful. And I don't want to yell back. She don't hear me. And I don't want to raise my voice. So I keep walking. I've been ignoring them for the last 2 years. I want nothing to do with them, honestly. I'm home as little as possible.
Okay. What's the parking situation? Explain that to me.
So we were having off schedules. And so we have 4 people in our household that have vehicles. Everybody is on the lease.
Okay.
So the 2 additional, which is my mom and her boyfriend, they're on the lease.
Yeah, but he's saying that I'm not concerned about that. Even if
So
they are, if they aren't.
pretty much, I'm a great driver. So I would occasionally use the portion to get out, sometimes get back in. I wouldn't tear up the gravel. I wouldn't park there or anything. I would use it for 3 to 5 seconds to get back in the spot. And then that was it. There was no damage to the sidewalk or gravel or anything else because it's a sidewalk, it's concrete. But there was no damage, no nothing. I would use it for 3 to 5 seconds and get back in because we have wonky schedules.
Okay.
Also,
I mean, is there a way to park either in the street or, I mean, clearly that bothers him.
I talked to the realty company and we're making a gravel pit in our front yard, but me driving 3 seconds on concrete and gravel for him to vandalize our property.
I'm not,
Yeah,
I'm not justifying. I'm going to come back to him on that. It's inappropriate for him to do that in any circumstances.
but yeah,
That's my,
so
but my point is, you know, you can respect his right of way and gravel area and all of that sort of stuff.
Yeah.
And so, yeah, well, it's only 3 seconds, but you know, to some people, 3 seconds is a big deal.
so we contacted the realty company, which they knew that we were driving on it anyways. And they gave us the okay because they had to talk to the actual owner and we're able to now make a gravel pit.
But if it's okay, but if it's his right now, even though, I mean,
we haven't ever
say,
since
for example, you can't, you know, the owner might not necessarily, if it's his right of way, his portion of the thing, you know, the owner can't, like if you're an apartment, for example, and some renter is, it's one apartment, you know, and going into the other person's apartment, you know, and well, the owner said it was okay. Well, the owner can't do that. That person's a property. He has a right to that particular area. The same might be true for this parking situation where that's his, and for whatever reason, he doesn't want you there. You know, the owner can't give you permission, say something, you know, over, well, he's paying rent, that he gets to decide that. See what I mean? You following my example?
Yeah.
So my question to you is, can you conduct your parking activity out there in a way that avoids that? It may be a little bit inconvenient for you, but I know it's clear to me that the way you're doing that makes it convenient for you. But go ahead, you were going to say something.
I was like, we have now, ever since the videos that I sent back to back, because I contacted the realty company after that. And ever since that, we haven't moved the cars whatsoever.
And then with regard to, is it your child?
So I have,
how many children do you have?
We have a 7-year-old.
Okay.
But every house on that block has about an 8-year-old and under
But
with multiple kids.
I'm not worried about other people on the block. I'm only worried about the only people in front of me are you and him. And so he said that, you know, he thinks, for right or for wrong, and I'll come back to him in a minute, that one of your children is bugging him. And, you know, you could say, hi neighbor, might seem friendly, but I could see where that can be kind of done where you're trying to egg someone on, or do you have a response to that? How old are your children?
7 years old.
Okay.
She's friendly.
Okay. Sure. Could you maybe talk to your child? Think, well, maybe Mr. Bresnovich doesn't appreciate that, so maybe you could just leave him alone.
Okay. Well, also in the beginning, he was friendly. He would let her go pet his dog and everything else.
All right.
But yes, I can talk to her.
All right. So, Mr. Bresnovich, I'm going to come back to you. I'm assuming you were hearing all that?
Yes, Your Honor.
Okay. And so that hopefully they can respect, you know, your portion of the parking area. And I get all that. But at the same time, you know, and I appreciate, you know, thank you for, you said you were a veteran, you know, thank you for your service. And I appreciate all that. I know clearly you're going through a difficult time. I get that too. But you just can't throw bacon grease on people's cars. You just can't do that. You must understand that, don't you?
I do understand. Can you imagine what it took for me to get to that point? How much of a
Well,
jerk you have to be for someone to get to that point? I didn't wake up one day and think, this is what I'm gonna do with my day.
No, but I don't suspect that, but that's just that's not a justification. I can't look at that and say, well, yeah, he was aggravated, so I can understand that. But I mean, it's again throwing, in the manner that you did, and they say that stained the car, and I'm not sure whether it did or it didn't, but that you just can't do that.
I don't want to do it again.
Okay. So what's going to happen today is based on what's presented.
Your Honor, more if I may.
Go ahead.
Those allegations with their kid and talking to the neighbors, that's some seriously defamatory behavior. She should be required to apologize for that. I want nothing to do with any of their kids. I wish them healthy, long, joyful life.
Okay, well, good. And I don't, okay. I appreciate what you said. But what's going to happen here today is I'm going to enter orders, 2 orders that basically just says you're just not to contact them. And that's it. And so hopefully that'll just be a bright line, because I perceive, going on their property and, and the flowers, and frankly, throwing the main concern is throwing grease or something on their car. That's, I consider all that leads to the point where orders are going to be entered, but there's not going to be a distance restriction. There's not going to be any sort of anything like that. It's just stay off their property and just don't contact with them, and that's it.
What about that back patio where they're within 20 feet of my house smoking and joking? Can we do something about that? We got Washington.
Well, no. Well, first of all, they're the ones who brought the order. And, in terms of they're on their own patio within again, there's not a distance restriction. You can be on your property. There can be on hers. You just can't you can't go on to theirs. And, and if I'm not making any ruling on that. If you feel that's harassing, you can ask for your own order. But I don't know. And again, I'm not out there watching it. They're hearing this. Maybe, hopefully they can conduct themselves and I don't know what's going on out there, but maybe they're mindful of that. Maybe they can take a look at how they conduct themselves on their patio. But no, there's nothing, that's not really in front of me right now.
What about the security camera that tracks me as I come in and out of my house?
Well, I can see the security camera that I've seen. Again, they're not in front of me on all of that. The security camera that I've seen what was presented to me was on their driveway, looking at their trucks. If you feel like they're cyber stalking you or stalking you in some manner, you're free to go get your own order, but you're going to have to show all that. And but for today, the only thing in front of me now is their order asking for you to not contact them. And based on what I've heard, both from you and from them, I'm going to grant them. But again, no distance restriction, just stay on your property, stay off of theirs, and don't have any contact with them. And the order will be in place for 1 year.
No problem.
I hope not. And I hope that now that everybody's kind of on the same page, you can get along. You do have to live next to each other, and life would be a lot easier if you could all of you could conduct yourselves in a manner that doesn't aggravate your neighbor, both sides. But given what's been alleged, I am going to, again, they're not, the parameters of the order is just stay off your property. And he's to stay off your property. He's not to contact you.